Welcome to day 2 of the Connecting Caregivers Conference. We had a fabulous day yesterday, got so much great response. And today we have another full packed day for you, starting with the fabulous Sean Scott. So happy.
Morning.
Good morning. So I'm going to turn it over to you, Sean.
Well, great. Well, have you had your coffee yet this morning, Linda?
Got my tea.
All right, here's to you. Here's to another great day. Thanks for having me on the conference again. This is always a fun thing that we get to do. One of my favorite things to say about this whole endeavor is that I'm not sure anybody can find the kind of information that you're going to get in this forum, this easily presented with such quality and such depth of knowledge anywhere else on the planet. It's really a fabulous thing you're doing here, Linda.
Thank you.
What we're doing here this morning with me is that we're going to talk a little bit about getting older and what that means in the caregiving space, as well as what happens in the event that you can't take care of yourself or you can't take care of your loved one and you need more help. So when we talk about those things, we often look at the expense and the cost that entails. And boy, I tell you, getting older is not for sissies, nor is getting older for people who don't have very much money. And when it comes to paying for the cost of care, not having much money is a real big number, actually. So in our community right now, when we looked at paying for the cost of care in a nursing home setting, a skilled nursing setting, that cost can run around $10,000 to $12,000 a month. In other communities across the country, it can be even more. When we look at a $10,000 to $12,000 a month bill coming into your budget, what's that going to look like to you? I mean, are you able to afford that? Is it going to be a big deal for you? Is it going to hurt you financially in some way? Well, I think the reality is that, wow, yeah, not very many of us can afford that bill on a monthly basis. And that equation, so to speak, financially speaking, is one where it spells financial catastrophe. When I talk about this with clients, we discuss the fact that you only have so much money coming in each month. That's kind of what your budget is. And in that scenario, you keep everything balanced. And then something like the cost of care, either in your home, in a home care setting, or let's say in an assisted living setting, or ultimately in a nursing setting, comes in and really unbalances the equation. And you get that thing called severe negative cash flow. And severe negative cash flow is something where you got way more money going out than you got coming in. Again, that equation really equals catastrophe for the family. You eventually will run out of money because where else are you going to get it? And the situation here is that, wow, well, how long is it going to take for me to run out of money, Sean? Well, in a caregiving situation like a nursing home, let's just do the math, keep it simple. Look what you have in savings, look at how much money you have, your life savings, so much you've reserved or squirreled away, and then take that number and divide it by 10,000. Well, that's how many months you're going to have until you run out of money. And that's just a simple math problem. So again, the dilemma becomes, how do we pay for it? So you look at different sources. We joke that, well, I guess you could always go out and rob a bank and see how that works for you. Robbing a bank is a way to get more resources. You get more money that way, I guess, at least hopefully. But it comes with some downside, not the least of which it's illegal. And if you get caught, well, you're going to jail. And again, there's some dark humor. At least you'll be taken care of. Right, it might solve your problem, right? So in a situation like this, we call it the federal penitentiary and nursing home.
Yeah.
So again, a little dark humor, but obviously that's not a solution. So can you invest your way out of this? Can you just reinvest your money in some more better, special, spectacular way so that it's going to produce more income for you so you can pay it for the cost of care? Well, that's unlikely. If you could do that, you would have already done it. You would have already made or would be making that money. You can't just snap your fingers, decide, oh, I'm going to make $10,000 more this month than I did last month. Highly unlikely. So you look at some other solutions. You look at Medicare, for example. Everybody knows about Medicare. Medicare's health insurance for people who are older. That health insurance takes care of a lot of our problems, takes care of doctor bills and physician bills and prescriptions, or at least most of them. Medicare even does take care of a little bit of the nursing home cost. If you've been in a hospital and had something issue, a shoulder repair, hip break, something along those lines, and now you're going to the nursing facility for rehabilitation, then that'll be picked up by Medicare, at least for a short period of time. And that period of time that Medicare will take care of that problem is limited to 100 days. Medicare really only pays 100% of the bill for the first 20 days. And then day 21 through 100, there's about almost a $200 a day copay that the patient has to pay. So this is a partial solution. It pays for some of it, and it pays for a little bit of time. But when the person hits day 101 in the facility, that say they're not able to get better enough to go home, or even to the assisted living facility, they get to that point on day 101. They go into something we call private pay. And what private pay means basically is you get your checkbook out and you privately pay for that as opposed to your insurance. A little footnote on Medicare. Medicare, again, picks up 100% of the bill for the first 20 days, most of the bill from day 21 through 100, but you're not guaranteed the 100 days. That 100 days is a maximum. If the person that's in care, that's rehabilitating, stops getting better, they plateau in their recovery. When they plateau in that recovery, what happens is Medicare pulls out. They say, we're done, we're sorry, but we are only here to get you better. And once you stop getting better, once you've plateaued, then Medicare will terminate its coverage. And this can happen on day 35, 55, 75. So the point here is that you're not guaranteed that 100 days. If you're looking at Medicare in the long-term care space, basically what I look at it is it gives you a little bit of breathing room in some situations to kind of do an assessment of the situation to say, okay, how big of a problem is this? Are we going to get better? Are we going to be in the nursing home for a longer period of time? And are we maybe going to have to go to an assisted living facility after this? You know, what's your trajectory? How are you doing? What's likely to be coming down the pipe? So Medicare, interesting, not a perfect solution at all, not even really a solution. So then you look at some other ways of doing, well, how else can you pay for care? Well, you can pay for care with long-term care insurance. Many people will have a long-term care insurance, actually not many, very few people have a long-term care insurance policy. Insurance that they're going to manage that risk by buying a policy that says that the insurance company will pay for the cost of that care if and when you ever run into that problem. This, in my opinion, is a great solution. I think I'm a big fan of long-term care insurance. I think people should strongly consider getting it if they have the ability to afford it and they have something to protect with buying that insurance. Long-term care insurance can provide care inside the home, provide care inside the assisted living facility, and ultimately can pay for that $10,000 to $12,000 a month in the nursing home. But here's the deal. If you're going to be going in the direction of long-term care insurance, a couple words of advice. One is make sure that you buy enough coverage. Don't underinsure yourself. There's no reason having $100 a day policy when it costs $10,000 to $12,000 a day, a month to be in the nursing home. So make sure you have enough coverage. Related to that, make sure that if you're buying a policy that it has some sort of inflation rider. And what that means is that as the cost of care increases every year, that the cost of your coverage will at least attempt to keep up with the cost of that. So make sure you have enough coverage. Lastly, when you're looking at long-term care insurance, explore something called a partnership plan. Partnership plan is a very cool thing. The government has basically said, hey, listen, partner with us, partner with the long-term care insurance company. And what we're going to do is we're going to help you or let you actually buy yourself into Medicaid. That's the simplest way I can put it. It's pretty cool, actually. So if you assess and you look at your situation and you say, well, gee, let's just pick a number. I have $150,000 in assets. I'm a single person. That money's at risk if I were to go into a nursing home. Well, I only need $150,000 worth of coverage to protect that. And the state of Florida in this particular situation says, yes, if you do that and you buy $150,000 worth of coverage in this partnership plan, then when that company, the insurance company, pays all that money out for you, and the policy's done basically because it's paid everything that it was obligated to pay. Florida says, we'll let you keep an extra $150,000 in assets when you apply for Medicaid benefits. pretty cool. So it's this kind of hybrid. It's insurance and it's also Medicaid, and you're putting some of the bill yourself. You're insuring yourself. It's not a bad thing. Again, you got to get it, you got to afford it, and you have to be healthy enough to get it as well. So these are some issues. A lot of people don't have it. The reason being is they think it's too expensive, and or they've waited too long in order to get the policy, and they're too old or too sick in order to be insured any longer. So be careful. You got to do this in advance. When I talk about too old or too sick, it's like trying to buy a home insurance policy, a fire insurance policy for your home when there's smoke coming out of the windows. I don't think the insurance company is going to touch you in that situation. So be very careful. Make sure if you're going this route, you do it early. And so now we're going to turn our attention to Medicaid. So this partnership plan is one way of qualifying for Medicaid. Why is Medicaid important? Well, let me tell you why Medicaid's important, because I believe it's pretty much the only solution that we have in our country for paying for the cost of this care that's actually accessible to most of us. All right. Medicaid and Medicare share a lot of sounds together. They look familiar. They do similar things. Medicaid, Medicare. So a lot of times when I'm talking about Medicaid, I'll say Medicaid with a D. And when I talk about Medicare, I'm talking about Medicare with an R. There's a lot of confusion between these two, and they're misused a lot of times. Interestingly enough, they were started at the same time under President Johnson's administration back in the day, so to speak. Johnson was trying to get health care for everybody in the United States. Unfortunately, that was not able to be done. Some political reasons for it, apparently. Not that those are relevant in this situation. So Johnson wasn't able to get health care for everyone in the United States, but he was able to salvage two different programs. One, health care for older people, that's Medicare, and then health care for poor people. Healthcare for poor people, we call it Medicaid. So if you think that there is an issue here where Medicaid is only for poor people, there's a reason why you think that, because that's its original, I guess, originally why it was created. Interestingly enough, when it came time to looking at, what program, Medicare or Medicaid, should pay for the cost of a nursing home, for whatever reason, the powers that be at the time decided that they would put nursing home care in the pile of Medicaid, the poor people coverage, not the Medicare pile, the old people coverage. Wow. Seems like in hindsight, that was a silly thing to do, but that is the way it is. And unfortunately, that's where we are today, multiple decades down the road. So Medicaid, in my opinion, is pretty much really the only game in town to pay for the cost of this care. So that comes in to say, well, how do you use this Medicaid? What is it going to do? Well, it's going to pay for the nursing home. It's going to help pay for the assisted living facility. It'll help pay for care inside your home. On the nursing home side, basically in the state of Florida, you have to meet some requirements financially in order to be eligible for this program. These financial tests are a pretty big deal. Something we need to talk a little bit about here, though, is that if anybody's looking or watching this in the future and you're not in the state of Florida, your mileage is going to vary a little bit. There are 50 different Medicaid laws in this country. Every state in the United States is, in a sense, its own country, and they have their own versions of Medicaid in each state. They're similar in each state, but the details are wildly important. So what I say specifically here really only applies in the state of Florida. You always need to localize your specifics to the jurisdiction that you live in. All right, so let's get back to this Medicaid thing. How do you qualify for Medicaid?
John, 1 second. Somebody just sent in a question. They said,
yes, sir. Yes, ma'am.
if you have Medicare Advantage, won't it pay 100% after maximum out-of-pocket is met?
Well, that's a great question. So, when we talked about Medicare as an alternative, as a way of paying for the cost of care, Medicare has some other flavors itself. There are these Advantage plans. Typically, private insurance comes in and replaces your Medicare. I don't know if I really like the term Advantage plan. It seems to say that they're better. And I don't know, I'm not sure they always are. How a particular Advantage plan pays for the cost of care depends on that particular company. It's very similar to Medicare, but the details can be a little bit different. I don't know a single Advantage plan that pays beyond 100 days. As far as when copays start, when copays end, I've seen some policies that say on day one you have a copay, and then 20 or 30 days later that copay evaporates, and then they pick up all of it. So the details of that can vary a little bit, but for all intents and purposes, it's still only a temporary solution, and it doesn't pay past the 100th day. So great question. It's good. I don't get that question very often. So let's go back to this Medicaid thing. I want to qualify for Medicaid. All right, different in each state, you said, Sean. Okay, good. That's a point you need to know. But excuse me, what are the qualifications? How do you get eligible for Medicaid benefits? In Florida, there are 2 financial eligibility requirements to become eligible for Medicaid. These are financial tests, so to speak. You have to pass these tests. So Medicaid in Florida is going to look at what you get and what you've got. What you get, that's the income that you have coming in. What you've got, those are your assets. Some states, remember, there are different Medicaid laws, don't care about what your income is. New York State, for example, doesn't look at income to determine eligibility. They only look at assets. But in the state of Florida, we look at both things. We look at what you get and what you got, what your income is and what your assets are. Florida is known as an income cap state, an income cap. And what an income cap is it's a limit on how much income you can have. You're above that limit, you're disqualified for benefits. You're below that limit, thumbs up, you've at least passed that test regarding income. In Florida, and this particular year, which is 2024, the cap or limit is set at $2,829 of gross income per month, 2829. $2,829 of gross income per month. And that income is for the applicant, the person applying for benefits. So if that person is married, for example, which a lot of my clients are, it's a husband and a wife scenario. Let's say the husband's going into the nursing home. Don't add the wife's income into that situation. It's only the income for the person applying. In this case, it would be the husband, 2829. Also, that number, that 2829 number, is a gross income amount, not the net amount. Now, most of us don't deal with gross income on a day-to-day basis. We really only care what our income is available to spend, how much money are we putting in the bank, how much money we started with, and what our actual check is sometimes wildly different. If you're on Medicare, for example, there's a Part B premium, or so to speak, that's coming out of your Social Security check. And you got to add that amount back in to get up to the gross number. So gross is an important issue. Yeah, I remember my first job when I was in high school. I was 16 years of age. I was a lifeguard for the Florida State Park system. Did my first 2 weeks as an employee. I was super excited. I was going to go out there. I was going to making all this money and run up to the office at the end of my shift. I get the envelope, my check in it. I open it up. I unfold it and look at it. And I'm like, oh yeah. Well, wait. Who's this FICA guy and why does he have all of my money? So introduction real fast into the world of net income versus gross income. So since that line is such a hard line in Medicaid, it's a bright line. If you're above, you're disqualified. If you're below, you're okay. Gross income becomes an issue because if that pushes you over the line, disqualified for benefits. So that's a problem. Now, in the United States now and in Florida also, there's a solution to that problem. It's called an income trust or a qualified income trust. It's kind of its official name. This tool allows you to fix that problem. Now, this whole solution actually came out of a case in Colorado. There was a guy by the name of Miller. He was trying to get eligible for Medicaid to pay for the cost of his care. And he checks all the boxes as far as, how old he is, how sick he is, what his assets are, all these things that you need to check to qualify for Medicaid. And they get to the income side of things. And lo and behold, let's say for the sake of the story, that he's $1 over the limit. He's got $1 too much. So the state of Colorado says, in essence, too bad, so sad. You're not eligible for Medicaid in the state of Colorado. And I'm making this part up. They hand him a map to New York and they say, good luck with your trip. Hope you enjoy the state of New York. Now, the reason why you'd be going to New York is because Medicaid doesn't look at income in New York, as we said before. This guy Miller wasn't happy about this. So he basically sued the state of Colorado and said, no, this isn't okay. And he finds this lawyer in Colorado Springs, a pretty brilliant person as it turns out. And this lawyer makes the novel argument to the court that, Judge, this is just not fair. Miller's not being treated fairly here. And now normally when you go into a court and you argue, it's not fair, Judge, it's not an argument that takes has much weight or has much persuasive ability. But weirdly enough, this lawyer says, hey, it's not fair. And let me tell you why, Judge, because the federal Constitution applies here. There's some federal law involved in Medicaid. Medicaid is being mostly, at least partially, funded by federal dollars. Therefore, if it's federal law and has some federalness, it has to comply with the federal Constitution, the big guy. And that thing says that if it's a law, it's a federal law, and it's being applied to a person in one state, it has to be applied to them equally, the same, basically, in all the other states. It's called the Equal Protection Clause. Basically, you got to be treated fairly, and you can't be treated differently from one state to the other. He makes this argument, and lo and behold, the district court says, wow, you're right. Miller's not getting treated fairly in this situation. And the judge creates a solution to make sure that Miller doesn't have to go to New York. And what the judge says, it says to Miller, basically, if you go out and you create this trust, basically a bank account in the name of the trust, and every month you put the amount of income that you have that's too much, that's keeping you from being eligible for Medicaid, if you put that excess amount into this trust, then you'll be at or below the income limit, and that will not keep you from being eligible, being disqualified, I should say, in the state, in Colorado. And therefore, you're being treated fairly now. Wow, this is huge. Because what we could do now is take that ruling, take what that judge said about Miller, do the same trust here in Florida, and we're good to go. And now all of a sudden, the income problem goes away. So here's the current status of the law. By the way, we love that trust and that solution so much that early on, after the case was decided, we called this trust a Miller trust, after the guy who was the plaintiff in the case. So if you ever see that in your research, or you hear something from your friends, or somebody out there says, "Oh, Miller trust," you look into a Miller trust. Well, that's what we're talking about, and now you know how it got its name. All right. Miller Trust, now called a qualified income trust. How does this thing work? Super simple, and if I can, at least hopefully I can make it super simple for you. A document signed. That document's called an income trust agreement. Once that document is signed, go down to the bank, open up a checking account in the name of the trust. Each month, deposit into that bank account the amount that the person is over the income cap. Brings them down to the cap, thumbs up, we're eligible. Rinse and repeat every month for the duration of the problem, for as long as we need Medicaid to pay for the cost of care. Super cool, super amazing. There is one little problem. The one little problem is finding the right person, or finding the person to sign the trust. There's a handful of people that can sign this trust under the rules. One person is the applicant. Mr. Applicant can sign the trust. Great. Well, a lot of times my applicant is in the nursing home. He may be cognitively impaired, unable to sign things, and so he becomes not an option. If he or she is married, their spouse can sign the income trust on their behalf. This is also very helpful and very convenient, because oftentimes we have that situation, and if we're over income, I can have the spouse sign it. Thumbs up. If there is a guardian that has been appointed, for whatever reason, a guardian through a court proceeding has been appointed to step into the shoes of the applicant, then the guardian can sign this income trust agreement. And lastly, we turn to the power of attorney. Power of attorney persons, called attorney-in-fact, they are able to sign the income trust in most cases. And so in many cases, we're looking at the son or the daughter, granddaughter, brother, some other family member, whoever's been made the power of attorney in the situation. We're looking to them to sign the income trust. Great. But here's where the little bit of a catch comes into play. Especially in the state of Florida. The state of Florida, the way the rules work, the way the law works regarding powers of attorney, is that they're strictly construed. Strict construction, what does that mean? In simple terms, that if the document doesn't say your backup person can do a particular thing, then they can't do it. So the power of attorney document has to expressly state that that person can create trusts. Not only does it have to state that, but it also has to be, you have to be very careful about what adjectives you put in front of that trust. For example, routinely, I see power of attorney documents that say that my backup person, again, my attorney in fact, can create revocable trusts on my behalf. Revocable trusts. That sounds good, but it's not good, because you can only do what the document says you can do. And if you can only create revocable trusts, it doesn't get us to the point where Medicaid is going to let you sign an income trust. Well, why? Well, under the rules, an income trust, and I know this seems nitpicky, but this is the way it works. An income trust is an irrevocable trust. That's an IRR revocable trust, not a revocable trust, REV, but an irrevocable trust. So if your backup person can create the REV type, the revocable type, he or she can't create irrevocable trusts. And now we're kind of locked out, and that power of attorney is not going to work. Also in the state of Florida, we have an interesting little spin on this as well. The state of Florida legislature, a recent reworking of the power of attorney statute, which, by the way, needed to be reworked. It was really, really bad with the old version. The new version, much, much better. But the legislature did come and give us a little bit of curveball in there as well. And they said that there are 7 particular things that your power of attorney can do. We call them the 7 superpowers, 7 particular powers that if you want your power of attorney person to be able to do that, that particular paragraph in that document that says what they can do, that particular thing, has to be initialed. So there's 7 of these things. Nothing else has to be initialed, but these 7 particular things do. And if you don't initial that paragraph, that person doesn't have the power. First on the list, what needs to be initialed? The ability to create a trust. Every day in my practice, I review powers of attorney, and every day I come up against a document. There it is, nice, new format, awesome. There's the 7 superpowers, great. There's the paragraph that says we can create trusts, no weird language like revocable or some other limitation on it. That's super awesome. And then right next to that paragraph, there's a line where the person's supposed to put their initial. And that line and none of the other 6 paragraphs are initialed. So that means all that wonderful language, including the language that I want, the backup person doesn't have the authority to create the trust because the stupid paragraph wasn't initialed. And this just, man, it just infuriates me because, if the dialogue I have in my brain is like, dude, and what I'm talking about is the lawyer that did this. You had one job. Okay. You needed to make sure this person had a credible backup plan so that person, the attorney in fact, could go out and be the principal, be mom, be dad if he had to be, and would have all the authority he needed to do to transact business. And you didn't tell the client to initial all the paragraphs?
Oh my
What the
God.
heck? Absolutely mind-blowing. I mean, it's to the point where I know a little graphic. I just want to like find that lawyer and like bang their head into the desk and say, dude, one job, how can you mess this up? But this happens every day.
Yeah.
So what I'm encouraging you to do is a little bit of a power of attorney challenge for everybody watching today. Is if you've already done one in the past, go out, pull it out of your files, take a look at it. Probably have never read it. Very common, not a big deal. I understand this, but read it for the first time. See if you can find a paragraph in there that talks about trusts, making sure that there's no weird language that limits your person as to what kind of trusts. And if you're in Florida, make sure that that paragraph's initial, because if it's not, it's wrong.
Wow.
One last thing on this power of attorney thing before we jump back on Medicaid. Be careful too. Even if you have the best power of attorney, they do tend to age over time. So the best practice, our advice to clients is make sure that your power of attorney document is 5 years or newer. So if you're a 10-year-old power of attorney, even if it's got all the good language in it, everything there, the best practice is to go and redo a new one every 5 years. Doesn't mean a 6-year-old power of attorney is not okay, but our advice to clients is every 5 years you should redo that document.
Sean, there's a question.
Yes.
Yeah, there's a question in the room. So my mother wants to have 2 power of attorneys.
Mm-hmm.
Is that possible? And what is your thoughts on that?
Two power of attorneys. Well, I'm going to assume that what they mean is they want two people to serve in that role. And I think that's a really bad idea. This happens a lot where I have clients that don't want to show favoritism to one of their kids. I love them both equally. I don't want them to think that one's better or more important than the other. All kinds of reasons. And I still don't think that's a good enough reason to name two people. Now, the thing I tell my clients and to make it kind of simple to understand is that there's a reason why they put one steering wheel in a car. Okay. I don't care how good they get along. Inevitably, they're going to disagree as to left versus right, or how much left or how much right. And now, since they're both in charge, that creates a conflict. And I will tell you that the worst family dynamics issues where things kind of start burning down, and the horror stories that you hear, in so many cases, that horror story starts with two people in charge at the same time.
Okay.
So don't do it if you can avoid it. I will draft the document. That way, if you insist, I will strongly discourage you. We will have a good talk about this, but ultimately, if that's the way you have to have it, we can do it. It's not illegal to do. It's just a bad idea. Also, from a logistics standpoint, one of the power of attorneys shows up at the bank on Monday and takes all the money out to do whatever, and who knows what needs to be done. And then the other power of attorney shows up on Tuesday and says, well, I just want to balance the account, make sure everything's okay, and says, where the heck's all the money? So banks, that's a very uncomfortable place for the bank to be.
Yeah.
So a lot of times they will require both power of attorneys to act, even though you say that only one has to act, in order to kind of cover themselves.
Yeah.
So it's just fraught with damages. I'm not damaged, fraught with issues. So
one more
I
question.
will say, however, let me say one thing more on this double person thing. I think you should have two people listed in the power of attorney, but not acting at the same time. So in my documents, for example, I appoint a primary person. He's power of attorney number one. And then I have a backup that says if power of attorney number one, the first choice, is not able to serve, death, incapacity, can't find him, don't want to do it, whatever, then we have a backup person that can come into the situation and step in and fill that role. So I think that redundancy is important. If your power of attorney that you review doesn't have a backup person, it should, and probably should redo it. What else you got there, Linda?
Should my power of attorney and healthcare surrogate be the same person?
Oh, that's great. So when we talk about powers of attorney, and they are what's known as an advance directive. They're incapacity planning documents. These are appointing somebody to be you in the event that you're incapacitated. And they generally come in two flavors. There's the financial side of things that's really kind of dealt with in the power of attorney situation. And then there's the medical side of things. And who's going to talk to your doctors? Who's going to make healthcare decisions for you in the event that you can't? So that's called, in Florida, a healthcare surrogate designation. Now, in California, the verbiage that they use, they have a power of attorney, and then they have a medical power of attorney. I really like the way that works, because I think it's more descriptive as to kind of the roles that these documents are playing. As to who should serve in the capacity of financial versus medical, it kind of depends. A lot of people will pick the same person in the same hierarchy because for whatever reason it makes sense. That person's the most capable, proximally, they're closer than other members of the family, they have a better connection, they're financially better suited for things. However, in some families, in some situations, let's say you got two kids. And one of your kids is an accountant and a financial whiz, and he's really good with money, and he's very conservative, and he's not crazy and wild all over the place. And you trust him if you couldn't make your financial decisions. You really would have faith that he would be a good backup plan. But when it comes time to talking to doctors and making decisions about that, he doesn't have a clue. He's not wired that way. He might, while he's conservative in these other ways, he might be very emotional in that kind of thing, doesn't really connect on that level. But your daughter, well, she's a nurse, okay? And she works in the healthcare field. Emotionally, the two of you connect really well. You have faith and confidence that she'll do what you want her to do, and she's connected and knows all the language and stuff. So there's an obvious choice where we would pick the son in this situation to be the financial power of attorney, and the daughter, the nurse, to be the healthcare surrogate. Now, that's a very overly simplistic situation, but it happens all the time. So people have to choose, and you don't have to choose the same person.
And you don't have to choose a family member.
That's a great point, actually. Do you have to choose a family member? And the answer is no. I mean, in some cases, I'll be meeting with a client. I'm like, okay, well, who's going to be our backup plan? And they go, Sean, that's a good one. My son, I love him to death. Can't put two sticks together. And my daughter, half the time, she's traveling somewhere in Peru with, and the indigenous people, and a great, great person, but hard to get to. I don't talk to her very much. So neither one of those would be a good choice.
Right.
So you can choose somebody else. You can choose another family member, a sibling, for example, or a parent, if depending on your circumstances. Or if none of those make sense, you can choose a trusted friend. And Linda, I think we've talked about this before. You have a trusted friend. And
Yeah.
if you had a situation where something needed to be decided and you couldn't do it, you'd rather her do it than anybody else.
Yeah, because you know what? My family, they all love me, but my family would have me plugged in for 100 years. And that's not what I want.
That's not what you want. Exactly. So choosing somebody other than a family member, well, not common very much because of just the world and the way it works. It's absolutely an option, and sometimes the best option. Okay. Good. Awesome. So we talked a little bit about income, how much income you can have. We talked about there's a solution to this problem, that you can use this income trust in order to get around it, in order to fix it. It's a little wild. Medicaid is filled with these kind of seeming contradictions on things. So they have a rule that says you can only have so much income, and then the next rule in the book says, well, yeah, but if you do this, you can avoid the first rule. Kind of crazy. The takeaway is that it's a fixable problem, and in order to make sure you can fix it, make sure your power of attorney is okay. So then we switch. Let's pivot to assets. How much assets you can have. This is, the stuff that you got. Now, the state of Florida, and pretty much every other state, limits the amount of assets that you can have. And the state of Florida actually divides the situation. They have two different asset limits, two different asset caps. So how much stuff you can have. So if you're a married couple, there's a married asset cap. And if one of the married couple is going into care, let's just keep it simple, talking about nursing homes. And we want to qualify for Medicaid benefits to pay for the cost of that nursing home care. The state of Florida says that the couple has to have $156,000 or less, $156,000 or less in assets. Otherwise, they won't be eligible for Medicaid. This is the asset cap. Okay. That's what that means in a practical sense, is that if you're a married person in the state of Florida, there's at least some reasonable expectation that as you sit right now, if you have less than 156,000, you're good to go on the asset situation. You can put a check in that box because you've passed the asset test. Now, when I say $156,000, it's actually $156,000 in countable assets. Countable, huge, huge, huge important term in Medicaid. When I say that there's countable assets, that means that there's another column of assets that are called non-countable, assets that are not counted. And the two biggies that are not counted are your home and your car. And these are typically the two of the biggest items that we own. So the value of your home and the value of your car are not calculated into the $156,000 number. So that's pretty cool. If you have $156,001, you don't pass the test. You're not eligible for Medicaid because you have too much money. That's kind of where people like elder law attorneys specifically, get involved in order to help you fix that problem, in order to advise you on to strategies and things that can be done in order to fix the over asset problem. So,
is 401k counted in countable assets?
That is a wonderful question. Excellent question. The answer is initially yes. 401ks and IRAs are what are considered tax qualified investments. That term means that you've never paid any income tax on that money that's in that investment. When you take that money out of that investment, then that's a distribution to you and it's taxable income on your 1040. So these are usually used in retirement. After I think it's 73 now, you have to take a required minimum distribution, but the interest and then the increase in that value over time has never been taxed against you, nor has the initial money that you received been taxed against you. So very nice investments. Does Medicaid count them as an asset for determining eligibility? The answer is yes, Medicaid counts them. That's the bad news. The good news is that we have a strategy that I refer to as my David Copperfield strategy. And I'll explain that in a second. But I use this particular technique or strategy in order to fix the problem and make it so that Medicaid will not count that investment. Interestingly enough, I learned this early on in my career, probably the first year I started practicing in elder law, which was 34 years ago, so it's been a while. I was in a hearing with the judge, the Medicaid judge, and we were looking at eligibility. And after we got done with our case, we were kind of chatting a little bit, and she says, "Well, Sean, on these IRAs, if you do this and this, we won't count them." And you have to remember that back when I started doing this in 1990, there was really no classes in law school on this. There was no place to go to learn how to do this. There was no books written on teaching you how to do this. It was just, there was nothing. So you were really going out and looking at the statutes and kind of reverse engineering and figuring it all out. And so I was still, my first year figuring this out. And the judge was very nice to say, well, if you do this, this, and this, then we won't count it as an asset. I'm like, really? Cool. So what happens in this situation is that, and again, the reason why I call it the David Copperfield strategy is, if you know anything about this guy, he's not a magician. He calls himself an illusionist. And as an illusionist, he doesn't actually make the thing disappear. It doesn't make the Statue of Liberty disappear, but he makes it appear to disappear. So it's an illusion. The Statue of Liberty hasn't gone anywhere. It's still there, but you don't see it. So I remap that onto my Medicaid strategy here, and I make that IRA or 401k appear to disappear. And we do this by adjusting kind of some of its characteristics. And we make it look like a pension plan, basically. And a pension plan under Medicaid rules is not counted as an asset. So when we start taking a specific distribution on a regular, periodic, and automatic basis, which is what the rules say, and you have this established, and you go to the department and say, well, here's this asset. It's an IRA or a 401k, and here's what we're doing with it. And we're taking these regular, periodic, and automatic distributions according to the formula that we have to take out. Medicaid's not going to count it as an asset. So initially, yes. At the end of the day, no.
Right.
But Linda, that also applies to basically every other asset. Now, there's different techniques to do this, but kind of the role of the elder law attorney is to make these things appear to disappear in a sense to make sure you meet the eligibility requirements for Medicaid. So it's not just IRAs that can be protected or 401ks. It's basically everything that can be protected. So good question. So countable versus non-countable. The house is not counted in Florida. Let's just talk about the house for a second because it's kind of an important issue. In Florida, our Florida Constitution has a very interesting provision in it that says that if your home goes to a family member, somebody related to you by blood, then that home will not be able to be taken by Medicaid when you're dead. So Medicaid, we like to say, doesn't actually give you any money. Medicaid is effectively lending it to you to pay for the cost of care. And when you're dead, they want their money back. This is called Medicaid estate recovery. They're trying to recover from your estate the money that they paid out on your behalf. And you're going through the Medicaid process, the probate process after you're dead. Medicaid shows up as a creditor. They raise their hand and says, hey, listen, you owe us a bunch of money. And before you can give anything to the beneficiaries, you got to pay us first. That's kind of the way it works. So the way Medicaid and how the asset side fits kind of susses out in most cases, the person may oftentimes have a home, wasn't counted, didn't destroy their eligibility for Medicaid, but when they're dead, Medicaid would like to get repaid. And so there's that big, fat, juicy asset. And they say, well, listen, before you give that house to your family or your kids, we want it. And in many states, this is a very big problem. In Florida, thank goodness, it's not an issue because the Constitution of Florida says that if it's going to a family member, no creditor can assert a claim against it, and that includes Medicaid. So the house is kind of super protected. It's not counted as an asset, and Medicaid can't touch it after you're dead. So if you are a single person, that's a little bit of a different story. If you're a single person in the state of Florida has a different asset limit, not the $156,000 that a couple can have, but a single person instead can only have $2,000. That's $2,000 in assets. That's a huge difference.
Yeah.
And what you might think, right? And most people, when I say this, are like, whoa, that's just not fair. Okay, yeah, I know fairness, remember, not usually an argument that works and doesn't work in this situation for sure. That is just what the numbers say. A person that has more than $2,000 who's single is not going to be eligible for Medicaid benefits and has a significant problem. Again, footnote, again, that problem is solvable, but initially going in, not eligible. And what this means from a practical sense, from the kind of real world scenario, is that if you're a married couple, there's at least some hope that you're going to be eligible for benefits. If you are a single person, pretty much going in, you're going to be disqualified because you have too much assets to qualify for benefits at that $2,000 number. Now, a little bit of dark humor here. People often say, well, how do you solve this problem, Sean? Well, how are we going to fix this? And I oftentimes will say, well, there is a solution to this problem. And it's a solution that you actually don't need somebody like me to solve. All you have to do is write a check to the nursing home every month. And eventually you will get to your asset eligibility number. What does that mean? You're just going to spend all your money until it's gone. And what we do, we call this the do nothing plan. If you do nothing about this problem except continue to pay for the cost of care, eventually you will be at the eligibility number. We think that's a bad idea, obviously, and I want to make sure that everybody knows that you do not have to do that plan. There are solutions in this world where we can kind of come in, look at the asset situation. How are they owned? How are they categorized? What type are they? Are they tax qualified? Are they real property? Is it your vacation home? Is it your primary residence? Is it co-owned with you? All of these different variables come into play. And when we get all that picture and we see what the situation is, then we can craft a strategy in order to preserve and protect all of those assets. And that's the huge takeaway from today is regardless of what your income or what your assets are, you can qualify for benefits to pay for the cost of your care. I think that this in some ways philosophically is kind of a travesty. We shouldn't have to jump through these hoops in order to get this basic kind of care paid for. This shouldn't be some sort of wild exception to our healthcare coverage for old people that we cover them for everything except for the cost of care in a nursing home. We shouldn't discriminate against you because you got some different disease than the other person got. If you had cancer, we're going to take care of you until the final minutes and going to spend all this money on your care, on your transplants, on your chemotherapy, and we're going to do all this stuff because good news, you got cancer. However, if you get unlucky enough to draw the Alzheimer's card out of the pile, well, yeah, good luck with that. So I feel extremely passionate about this, that it just hurts me to my core to see people that go out and continue and just do that do nothing plan because they think they can't be eligible for benefits, that they didn't do it in time, that they have too much income, that they have too much assets, and they just keep writing that check until all of their life savings is gone. The huge takeaway from today is that you do not have to do that. Now, can you go out and fix this Medicaid thing yourself? Please don't take this the wrong way. It's not me trying to feather my own bed. The answer is no. Medicaid is wildly complicated. There are so much nonsensical provisions. One page it says stop, the next page it says go. One is up, the other one's down. Yes, no, maybe. How did you put it together? When did you apply? All of these crazy things. It's not possible, in my opinion, for a regular, normal person to go out there and fix this problem without some help from somebody that knows what they're doing.
Knows what they're doing. I got some questions here.
Yes, ma'am. Hit me. How are we doing on time, by the way?
Because
I don't have a clock in this place, so.
Well, we have like 10 minutes.
Awesome.
What happens if the well spouse inherits a substantial amount of money? Does this affect the nursing home spouse and Medicaid?
Oh, I love that question. I want to jump off of that and talk about another little subject in our remaining time, or at least a touch on that. But let's look at that question. So let's assume some facts to make sure that we, kind of clean it up a little bit. So let's say the sick spouse is on Medicaid. Let's just hypothetically say they're in the nursing home. We've jumped through all of our hoops. We've checked all of our boxes, the assets and income and everything that's perfect. We've applied and our spouse is receiving Medicaid benefits to pay the nursing home. Still married, by the way. And a year and a half later, the wife's great uncle dies and he leaves her $1 million in assets. Awesome. So the wife now has an extra $1 million. Does that affect her husband's eligibility for benefits? And the answer is no, it does not. The way the rules work in Medicaid is taking a snapshot of what's going on at the time of application. And that's when you have to meet this $156,000 burden. And so in essence, we moved all of that money into the name of the well spouse. Husband has 2,000 or less. She has $154,000 or 156, depending on exactly the numbers. But for all intents and purposes, money's in her name, not much is in his name. He's eligible for benefits. Post eligibility, what that means is after he's on Medicaid, if the wife's assets increase beyond that $156,000 number, it doesn't negatively affect her husband's eligibility for benefits.
Okay.
So that $1 million that she gets from the inheritance will not disqualify him. But no, unless she puts it into his bank account, which she's not going to do. Okay. So this brings up a little bit of an issue in husband and wife scenario, a very overlooked issue. And if you're watching and you're married in a married situation and your spouse is, a person you're taking care of, and we have a diagnosis of some sort of progressive degenerative issue, this is, I'll use the Alzheimer's thing again. You need to change your estate plan.
Yeah.
In many circumstances, when we have a husband and wife, a kind of a traditional plan for them is this reciprocal I love you plan. And it goes like this. It's like, baby, I love you so much that if I die first, I want you to have everything. And then the other spouse is like, well, honey bunny, if I die first, I love you so much, I want you to have everything. So it's this reciprocal back and forth type thing. And under normal, regular circumstances, it's okay. But when we have somebody that's either in the nursing home or going to the nursing home, predictive that they're going to be going, making your husband the beneficiary of all the stuff is a really, really bad idea.
Yeah.
Because if you die first, and Linda, in these situations, caregivers have a tendency to die before the person they're taking care of. And if they die first and their will says, hey, everything goes to my husband, well, that's a really bad plan because now he's single. He can only have $2,000 and you just put everything in his lap.
Yeah.
Bad idea. So
what
else you got?
It says if a home is JTWROS, will Medicaid use it to repay them?
Great question. Joint tenant with right of survivorship in the state of Florida, if that home is owned as JTWROS, which is a shorthand way of saying joint tenancy with a right of survivorship. This is a setup where the survivor owns the house, so to speak. So, Linda, if you and I own that piece of property and we were joint tenants with right of survivorship and I died first, that property would automatically be yours. You wouldn't have to go through probate. And if I was on Medicaid, Medicaid couldn't touch it or put a claim against it.
Okay. How do you make sure your home is going to a family member? Do you do a will? Do you do a trust? What is the best and more simple way?
Oh, great question. The best and more simple way. Now, I try to do the simplest solution I can for our clients, but the one that actually works for them. So the reason why I laugh a little bit about that is because there is no simple, easy way and all the time. Sometimes there is an option. Sometimes there's a more complicated option that needs to be used. So when we move a house, that's an estate planning question. There's lots of different ways we can move that house. We can use the joint tenant with right of survivorship option. Not a big fan of that because of having to create a co-ownership. We can use a living trust to put the ownership of the house into a trust, so the trust conveys it to the new owner when you die. That avoids the probate process. A lot of advantages to that as well. In the state of Florida, we have a very cool technique. I don't use it all the time, but it's very handy in many cases, and it's called an enhanced life estate deed, also known as a ladybird deed. None of that means anything to anybody that's watching. What I call it is a beneficiary deed. And it's the exact equivalent of putting your son or your daughter on your bank account as a beneficiary. So that when you're dead, all the son or daughter has to do is go down to the bank, death certificate, and say, hey, mom's dead. I'm the beneficiary on the account. The bank will just give them the money. No probate, no lawyers, no court, no judges, no nothing. Super simple and a very nice strategy to use when solving this house problem and how it gets to your heirs when you die. So that's another option. And again, it's a good option that many people are not aware of. So good question. What else you got for me?
We got one more.
What do you got?
I'm looking. What and when are cash distribution counted toward eligibility? How long do you have to have a clean slate in all accounts to not have distributions counted?
I'm smiling because I think if before we did the conference today, Linda, if you and I sat down and said, okay, what are like the 5 best questions that you should be asked, Sean, and you and I sat down and I wrote the questions, that would have been one of them. Okay, excellent question. So what happens in this whole giving thing away situation is that it's basically frowned upon big time by the state of Florida and Medicaid. So they don't want you to do this. However, there is a period of time after which those transfers and those gifts, they don't matter anymore. This is called the look back period. If anybody knows anything about Medicaid, they usually have heard about a 5-year thing. And what that 5-year thing, they may not know exactly what it is, but they know it's out there. Sometimes they think, well, if I didn't do something 5 years in advance, I'm out of luck, and boy, I wish I would have done something sooner, but I didn't, so Medicaid's not an option. That's wrong, by the way. That's 100% wrong, but that's the way sometimes it gets interpreted in the person's brain. What is this 5-year thing? What is that look? It's called a look back period. And what the state of Florida is doing is they're looking back in time from the date of your application for Medicaid benefits 5 years back in time. And they want you to disclose and tell them if you gave anything away in that period. So it's a look back period where you have to disclose if you made a transfer. That's what it is. If you've made a transfer within that period, it's a problem. Now, the problem is disqualification for Medicaid benefits. Cool thing about that problem, there's a solution. And that solution is something we call a retransfer. So we work with the client on having that money moved back into their name, and there's various different ways we can do that. It's always a solvable situation. If we know that you made a gift and you tell us about it, what you need to do, we can make sure that that will not disqualify you. The takeaway, though, is that if you got writing on the wall in the situation, in other words, you got a heads up that this problem is coming, you should probably not be giving things away because you're just digging a hole of disqualification. But if you've already done it, well, if we have to apply and it's within that gift or transfer was made within the 5-year period, we can fix it. All right. What else you got?
We're closing up now, Sean.
All right.
If anybody else has any other questions for Sean, you can contact him, or Sean is on my radio show the first Friday of every month. So please, we don't want your questions not to get answered. You can email me, you can call in the show, you can call Sean's office. Sean also does a lot of speaking engagements at local libraries here in Florida. You can go and ask any kind of questions, and tell them about your book quick.
Absolutely. Real quick. Again, thank you for having me on the conference today. I'm very passionate about getting this information out to people to make sure that they know there's a solution to this problem. And in order to get this information out, I've actually written a book on this. It's a plain English guide. It's pretty cool. It's written in regular, normal language that you can understand. This Medicaid handbook. You can buy it on Amazon if you want. We just came out with an audio version, an audiobook version of it, so you can listen to it if you wanted to do that. You can also give us an email, which you can get from our website at Florida Medicaid, flmedicaid.com. Put that into your browser, go to our website, email us. We'll send you a free digital version of it at no charge. Just let us know that you want it, and we'll get you a free copy of it. So,
Thank you, my friend. We'll talk soon.
all right.
Have a delicious
Excellent. Talk to
day.
you soon. Have
All
a
right.
great conference, everybody. Talk to you
Thank
later.
He is such a wealth of information. Every time I hear Sean, I learn something new, and that's what everybody else does, and I'm so fabulous about that.